Welcome everybody. I'm Ferris with Texas Multifamily Masters. We are part of Multifamily Masters. It's basically a national meetup group based here in we help run it between Texas and a few other territories. We have about 40 chapters throughout the country. And, as part of COVID, really, we decided to combine the two different Texas chapters. We have the Houston chapter and the Dallas chapter. And basically, let's go do one combined webinar. And so that is the webinar that we are on today. And so I'll go ahead and kind of introduce myself briefly and then hand it off to my Dallas friends, and then we can kind of introduce it to our friend Dugan. And so that said, I'm Ferris with Disrupt Equity. We are a vertically integrated acquisition and management company. We do have our own management company, which does first and third party management. And, we've done deals throughout Texas and Georgia, and we are constantly on the acquisition side. And so I'm Ferris, and I have my less handsome partner, Ben, who's not on today, but I'm here to represent us. And so with that said, I will go ahead and hand it off to John. You want to go ahead and introduce yourself?
Yep, absolutely. Good evening, everybody. John Montero, based up here in Frisco, in the DFW Metroplex, part of the Dallas chapter alongside Anton. I am a multifamily syndicator, operator, and developer. We buy A and B class assets in the primary markets here in Texas, DFW, San Antonio, Austin, and Houston. We also do ground up development. We have about 1,500 units in various stages of the new development ground up process in various markets in Texas. And looking forward to information packed evening with Dugan, who I have personally done several deals with on the syndication legal side. So looking forward to learning from him. I'll hand it off to Anton.
Hi, everyone. Anton Madley, co-founder and CEO of Peak Financing, also based in Dallas, a neighbor of John in Frisco, and pretty close to Dugan, who lives up in Prosper. So we are in the Frisco-Prosper triangle. All three of us have been investing and on the financing side of commercial real estate, including multifamily, now for almost 30 years. So I live and breathe that. And again, with Peak Financing, we help with the financing for commercial real estate, and we help a lot of multifamily syndicators on the financing side. And I look forward to hear what Dugan has to tell us tonight.
All right. Thank you, Anton. So with that said, I'm Ferris. My daughter's no longer here, so I can definitely keep focused. But, you guys aren't here to listen to me, John, or Anton, right? We're all here for Dugan. As kind of mentioned, Dugan's a good friend of, I think, all of ours, actually. We've all used him multiple transactions. I'd like to say one of the top syndication attorneys in the world because, there's no such thing as SEC attorneys, I guess, in other countries. So I think you get that title, Dugan. But, like I said, I've had fantastic experience with Dugan. Really, I think we've been working with him, Disrupt Equity as a firm for 3-4 years now, Dugan. And so, great experiences, and really figured, wanted to hand it off to Dugan to help educate people. And I think there's a lot of information and a lot of misinformation on syndication, and Dugan is here to help kind of, make the murky unmurky and help answer questions. And so with that said, Dugan, I'll hand it off to you and let you introduce yourself.
All right. Hey, everybody. So let me see here if I can share my screen. I actually sent I can. Look at that. How about that? What I thought I would do, and I'll tell you what, the guys that you have at the top of your meetup, they're top notch. I know each of them, and they're amazing men of integrity, and in their own right are extremely seasoned and experts in the world of syndication, from everything from raw land and development with John to multifamily to management to finding equity or debt for your deals. John, Ferris, and Anton and their wealth of expertise is the gold standard in the industry. So thank you very much for having me. I thought what would be kind of cool is something that's very unique in that a few of my clients. So last year we did $4 billion in transactions, and probably $1 billion of the $4 billion that I did last year in transactions was dealing specifically with this particular issue that does not get a lot of press with syndicators, operators, sponsors. Those terms are used interchangeably about how they might benefit their investors, or how you might think about deferring some of the taxable gains that either you as a general partner, you as a co-sponsor, or you as a passive investor are thinking about in the area of multifamily syndication. And so this is what some people talk about when they're talking about drop and swaps. Some people say splits, installation notes. Those sorts of things are very interesting to me, because now sponsors and syndicators are not only being able to take advantage of the tax advantages of commercial real estate, but in the syndication realm, they're taking the gains from the sale of a property that appreciated massively, and they're being able to use those proceeds again as seed capital for your next deal. And so I like to say one of the hardest things for anybody to do is raise capital in syndication. And so if you have the ability to accelerate your raise or shrink that time frame for sponsors and investors, you should definitely think about it. So this is a talk that I've given at a couple conferences around the country, and it's called Drop and Swap 1031, the key mechanics. So I like to say the tax code is a monstrosity, right? There's only one thing to do with it: scrap it, kill it, drive a stake through its heart, bury it, and hope it never rises again to terrorize the American people. Well, unfortunately, in the United States, we deal with what's called a progressive income tax. We have tried without fail, without the ability to succeed so far, to get a flat tax or something like that. The last congressional session, there was a lot of hubbub and drum beating about the fact that there was going to be some sort of massive shift, either in touching the doctrine of the IRS 1031, which is the ability to exchange the gains realized from the sale of a commercial real estate transaction, to defer that taxable gain. Thankfully, that did not happen. But it never ceases to amaze me that the tax code continues to increase each and every year, right? The hardest thing for most of us, even us that are in the space, even us that are have an expertise in this space, is to understand income tax, in particular on all of these issues. So my favorite section of the Internal Revenue Code section is section 1031. Why? Well, it is unique to what we are passionate about, right? It's unique to what we're all passionate about, and that is it allows us the ability to defer the taxable gain, or having to pay taxes on the gain from property that we sell, and kick that tax can down the road. It is unique to commercial real property. As of 2018, it is specifically geared only for commercial real property. So those of you that have been doing this for a while, I've been practicing law for over 22 years. We used to do tax-free exchanges with businesses, like pieces of art, boats, automobiles, things like that. We were able to basically sell those fine pieces, those unique pieces of personality, and do a tax-free exchange. No more. Uncle Sam has really gotten the grip on us, and has made it so that is only with respect to commercial real property. So this is a provision in the tax code that is used by investors who are selling one property and reinvesting those proceeds in one or more other properties. And if you're a sponsor, an operator, a syndicator, somebody who has the awesome responsibility of managing other people's money, you're a good steward of those people, those investors' money, you might want to think about how, if some of those investors might want to redeploy that capital into your next potential deal. So there's a little bit about me. Our firm's been around for a while. We've got brick and mortar locations in Dallas, Texas, where I'm right near where Anton and John live. And then we have an office in Santa Barbara, California. But most of my clients are operators, sponsors, operators, passive investors who are hunting, buying, and selling commercial pieces of real property all around the country. All right. Here's some of the basics. So I apologize if this is like some rudimentary stuff that most of you know, but for some of you that are listening or watching this may be a good refresher, or it may be something that kind of like piques your interest, that whets your appetite, that you start to think to yourself, hey, I might want to think about this if I'm a passive investor or I'm a sponsor and operator. So since January of 2018, tax deferred like-kind exchanges are limited to only real property, not personal property. So again, this is unique in the investment class. It doesn't apply to stocks. It doesn't apply to oil and gas. It doesn't apply to many of the other investment classes that historically have been able to benefit from things. It only applies to commercial real property. Now, the definition of what qualifies as a property that might be potentially of like kind is very broad. So for those of you that are in Airbnb, or you're in the fix and flip space, or you're in the mobile home space or the self-storage space, and you start to think, I want to get into the multifamily space, I want to build multifamily, you can go from Airbnb to development multifamily. You can go from self-storage to multifamily. You can go from mobile home to multifamily. It's very broad, but here are some of the requirements on the qualifying property, and that is both the relinquished property, that's the property you're selling. So that's either the apartment building that you've invested in that you're selling, or it's the Airbnb or the fix and flip that you're selling, must be held for productive use in trade or business, or, and here's the key words, it is held for an investment. And that's a lot of us that invest passively. I invest passively. I have lots of clients that invest passively. And so when you're investing passively, you need to hold that for personal use. Now, I get this asked question, well, what happens if I want to use the 1031 and buy a vacation house for myself? The answer is you can potentially do that with some qualifiers. But the reality is this specific section is really used for commercial investment opportunities. So it's not for your primary residence. Okay. It's not for your primary residence. All right. Deferred exchanges. These are the basic rules that you need to know when you're talking to your passive investors, or if you're a passive investor and you're wanting to know, when should I talk to the sponsors about the possibility of whether they're interested in doing a tax-free exchange? Well, imagine today was the day of closing. We were going to sell a property. Well, before today happened, before the closing actually happened, we would have gone out and hired what's called a qualified intermediary. That's a specialized entity or individual that provides what Uncle Sam says is a safe harbor. They provide safe harbor. They take possession in their escrow account, the money that we've realized from the sale that happens today. So let's imagine we sold a property for more than $1 million. We're making $1 million profit on a piece of property. How do we not pay taxes on that $1 million if today is closing? Well, hopefully a week or 10 days or 2 weeks ago, I would have hired this qualified intermediary. I would have signed their engagement agreement. It's not terribly expensive. Usually costs somewhere between $500, $750 to $1,000 for them to provide this service. They act in this special capacity. They take that $1 million into their trust account and they hold it. They don't use it. They don't flee to Mexico and use it for whatever else. They're going to hold it in their escrow account. And you're going to tell them within 45 days from today's date, you're going to identify some replacement properties. So imagine John has got a deal. You're going to identify John's deal as a potential replacement property, or Ferris has a deal. You're going to identify Ferris's deal as a replacement property. That has to happen within that 45-day time limit. And then within 180 days from today's date, we have to close on our acquisition, either of the interest, the undivided interest in the real property, or the property itself. Now, some people gloss over this next little nugget. I think it's very important because I just had a recent person who contacted me saying, hey, I want to do a 1031. I've talked to the sponsor of the operator. They're open to it. I said, great. what do you got to invest? They said $1 million. I said, all right, fantastic. You got $1 million you want to invest. I said, and the sponsor's open to it. And they said, yes, the sponsor's fine with it. I said, where are you at in your designation period? They said it just expired maybe 10 days ago or something. And I said, have you listed the property that you want to invest in? The property that the sponsor has, have you actually notified your qualified intermediary of that within that 45-day time limit? And they said, I think so. Well, that's not the right answer. We can't think so because the IRS, these are extremely rigid guidelines. They will not deviate. When COVID hit, they stretched them for a little bit when COVID actually hit and the financial markets kind of seized up and everybody was trying to figure out what the hell's going on, right? They expanded them a little bit, but that's not a guarantee. And so unfortunately, the person I was talking to that wanted to invest $1 million had not notified their qualified intermediary. Unambiguously, the tax code says you must unambiguously in a written instrument. That means something in writing. It could be an email. It could be on the back of a napkin, but it has to unambiguously say to the qualified intermediary, I intend to purchase an interest in this piece of property. And it has to, usually it has the name of the apartment complex or the property address. It doesn't have to have the from this degree to the third degree to the fence post to the hitching, it doesn't have to have the legal description, all of that mumbo jumbo, but it has to have the address, something that the qualified intermediary can actually lock onto. And then the last part is that what most people think is I'm only going to designate one property. And I tell clients this all the time. Don't just designate one property, designate at least 3 properties. That does not mean that you have to invest in all 3 properties for a variety of reasons. Maybe the sponsor is kicking the tire wheels and says, hey, we've done third parties. They come back. There's an environmental issue at the property. So as a result, we're pulling out. We're not interested anymore. Or they've crunched the numbers on their business plan and it just doesn't work. Or they can't get traction on the equity on the private placement side. Or their lending cuts proceeds by a couple $1 million. There's any number of things that can happen in the context of a commercial real estate transaction where the deal can actually go off or this way. But if you're an investor or you're a sponsor syndicator and you're thinking about what next deals to invest in, give yourself at least the ability to invest in 3 distinct opportunities and at least close on one of those within that 180-day time frame. All right, here are a couple terms that you're going to see consistently throughout this process. And the more advanced and seasoned you get in the commercial real estate space, you're going to see these things over and over again. This concept of boot, yes, you heard me. It's called boot. Boot is when a taxpayer, an individual or an entity receives boot in the form of cash or non-qualified property. Remember, the taxpayer recognizes taxable income to the extent of the boot, meaning the value of the boot. Now, if you're an owner and operator, and maybe you've been playing in states like Georgia or Tennessee or Florida or the Carolinas, and you've had some seller try to negotiate with you a distinction between the purchase price for the property, and then they want to allocate a portion of the purchase price for the personalty, right? The washers and dryers and the playground equipment or the stuff in the office. You got to be careful with that because that theoretically is personalty. That is not tied to real property. So if you're paying something for that, theoretically, that's not going to be recognized as something that you could do a like exchange for, and that could be theoretically a boot. Now, a reverse exchange. What happens if you're a sponsor, an operator, a syndicator, or you're a passive investor and you want to invest in another opportunity? In fact, you already found the next opportunity you want to invest into it, but you haven't yet sold the property, right? You haven't sold the relinquished property yet, but yet you've already identified that. And so a lot of people think to themselves, well, maybe I just can't do it. I'm out. I'm SOL, right? I can't do it. Can't make it happen. That's not true. There is this ability to do a reverse exchange. The downside, so a reverse exchange is where you're going to basically front the money. You're going to front the money necessary to get into that, the money that you theoretically would take from the sale of your property, and put that toward the replacement property. Now, instead of having a qualified intermediary, the title changes slightly, and they're called an exchange accommodator title holder, or EAT for short. But this EAT person is essentially functioning in the same capacity as the qualified intermediary. They are serving as a safe harbor to protect the taxable gain associated with you being able to replace the money you received from the sale when it happens, and it has to happen within 180 days, into that new opportunity. And it allows you to basically hold possession of both the replacement property and the relinquished property at the same time. So a reverse exchange is important. Related persons is just means that if you're trying to do something in connection with your wife or your parents or your children, and you do this within a 2-year period, the taxpayer must recognize the gain. It does not go beyond that direct lineage, though. So if you want to buy a property and do an exchange with like your crazy Uncle Larry, that's fine. That's not recognized as a related person, and there's not going to be a prohibition on such. All right, so here's the mechanics. This is the sexy sizzle stuff. This is the stuff that nobody in the country right now, very few people are actually doing. But of the $4 billion I did last year, close to $1 billion was dealing with sponsors, operators who were selling properties and allowing investors the ability to that when they didn't need liquidity or cash, or didn't have a life event that necessary, that they'd take those cash and pay their taxes, that allowed them to do something different. And this is called a drop and swap. So the drop refers to, imagine you've got a single entity that owns an apartment building. You're selling this apartment building. You have it under contract. Before it closes, you're gonna create a deed that quit claims part of the interest from your entity to the other entity, such that now you have two owners of what we call an undivided interest in real property. This is also called a tenant in common structure, or a TIC. Maybe you've heard that term, a TIC structure. So you create a TIC style structure, and then those two owners are going to ultimately generate a general warranty deed or a special warranty deed to the ultimate buyer, the buyer that has it under contract. That's called, and then one of those entities, so one of your, let's say you have one entity and 50% of your investors say, I want in, meaning I don't need the liquidity. I want to shelter the taxes. I don't want to pay taxes to the extent I want to go through the exchange process and go into the next opportunity that John or Ferris has for me. So I want in. What am I going to do? Well, you're going to drop 50% of the people in this entity, the entity that's owned this property. You're going to drop into this other entity. This new entity is going to go to closing. It's going to get its cash. It's going to pay its taxes. Those investors will receive the same distributions that they would receive on a pro rata basis at closing. The entity that owned the property is going to go through the exchange. That entity's share of distributions it will never receive, because those proceeds will go to the qualified intermediary, right? Remember, the safe harbor, and then they will redeploy that capital into something else. That is called a drop and swap. It's a partnership, because remember, even if you're an LLC, you're being taxed as a partnership. So if you're a passive investor, you've received a K-1 that shows your profits and your losses. You're being taxed as a partnership. That partnership distributes the relinquished property. It distributes part of its interest to another entity, to the partners, shortly before the exchange. Now, what's the downside, or what are the risks? There's always risks associated with anything in life. Nothing is free. So the reality is the tax code and the treasury regulations are silent as to how long a property must be held to satisfy this held for investment. However, we know from very conservative private letter rulings or other things that presumably the IRS would appreciate or like you to hold it for a long period of time, which means that the entity that has owned the property for a significant period of time is the most ideal entity to go through the exchange because it's owned the property for a long period of time. Versus if you're dropping investors into a new entity and that new entity goes through the exchange, in the event that the IRS decides to audit that transaction, there's a chance that the IRS may decide that that you did not hold it for a sufficient period of time, or this held for investment criteria was not satisfied. So that's the potential risk. So how do we mitigate that risk? Well, we mitigate that risk by trying to have the original entity that was syndicated, the original entity that was on deed, the original entity that sat there for 2 years, that you've invested into and received distributions or been sitting there waiting to receive distributions. That's the entity that goes through the exchange. And that's how we try to mitigate those risks associated with this requirement. Now, here are the key components again of the drop and swap. There's going to be another deed that creates this tenant in common structure. This tenant in common structure deeds it then to the buyer. The members or entity proceed to closing, and those who want to go through the exchange do so, and those who want their cash take their cash and pay their taxes. Your operating agreement, that's the legally binding agreement between the sponsors of the managers or the general partner of the syndication and you as the passive investor, needs to allow for this, or it needs to be amended to allow for this, okay? Those are the key components of a drop and swap. But what if I don't want to do a drop and swap? What if I want all my investors to go through the exchange process? I have some clients who have in their operating agreement, if the members vote for it, either a simple majority or a super majority, and they vote for it, then they'll go through, even over the objection of some investors. Now, I tell clients all this all the time. Remember, this is a rinse and repeat game, right? So you don't want to be running roughshod over some investors' objections or their notions of what fair play is. So you want to make sure that every investor has an opportunity to express its clear intent. So in many cases, what we will do is we will create a ballot. This ballot gets distributed to all of the investors. So all of the investors have an opportunity to express their clear intent. So remember, the clear intent, the default has to be that you're going to get your cash and pay your taxes, because that's the deal you signed up for when you were a passive investor in the syndication, right? You knew that the manager or the general partner had the ability to sell the asset. And then when they did that you were going to receive your distributions and you were going to have to pay your taxes. So what happens if I don't want to do the drop before, but I want to do the drop after the exchange? Well, that's called a swap and drop, right? So now we're doing the swap, meaning we're selling the property and now we're swapping it. We're exchanging it for another property, and then we're dropping. This allows you the mechanism to be able to take some investors who want to either hold their interest in their own name or in their entity's name, or even sell their membership interest after you find a replacement property, the ability to do that. And you as the sponsor or the operator could even set a time frame. Sometimes we talk about redemption rights as a sponsor or operator, right? Some of the offerings that you've either invested into or you've structured yourself might have a mandatory lockout period or a period of time within which the restricted securities, because that's what this is, can't be sold to a third party. Well, typically that sale process is after that period, after that lockout period. So if you're thinking about potentially doing a swap and drop, the partnership distributes the replacement properties to the partners shortly after the exchange. So they would go through the exchange, they'd buy a replacement property, and then there would be some mechanism in place for you as the sponsor, operator, or syndicator to be able to buy out or redeem those investors' shares in that process. Well, that's called a swap and drop. Now, what happens if you've got and here's just an example of what you could do is theoretically we have investors coming into the same LLC and then they're dropping out and being able to invest in other properties themselves. Okay, what happens if I want to do a split off? So sometimes I get to ask this question that, hey, there's multiple general partners on this deal, and not all of us want our cash. Not all of us but we want all of the investors want to take their money and pay their taxes. But we want either one or two of the general partners want the ability to do a 1031 or do that. And that's called a split off. And this is where the LLC, again, distributes the interest. So we're still talking about the tenant in common structure, right? You can kind of see the same ingredients, right? Between the drop and swap, the swap and drop, and now we're talking about the split off. This is where the entity, the syndicated entity, the entity that owns the property, distributes a property interest to the exiting member. So let's say you're a co-sponsor on a deal, and let's say you've got your position is maybe 10% of the overall deal, but you have a decent size of the general partnership or the class of membership that where the sponsors are. Well, theoretically, the split off allows the syndication to essentially, again, exercise a deed over to that entity and allow that entity to go through that exchange process. Now, remember that that held for requirement, that's a risk associated with the transaction because relatively speaking, you're doing these drop and swaps or the swap and drop or the split off sometimes in very short succession or in close proximity to closing, which increases the potential risks associated with the transaction. But remember, folks, and all of this, these are tax deferral strategies. This is not a tax waiver. So unless you're one of those extremely self-controlled people that's going to do over and over and over again with 1031, the reality is that you're at some point going to have to pay your taxes. And in the unlikely event of an audit or a disavowal of the actual exchange process itself, you have to pay the taxes that you owe to Uncle Sam anyways. In the split off strategy, one member or a couple of members receive their pro rata percentage of the general partnership, which is monetized at that point, and it allows them to go through the exchange process and then take those tax deferred gains into the future towards the acquisition of another interest or undivided interest in real property with on another project. This strategy avoids the held for investment requirement issue, but it may be attacked under the step transaction doctrine. The step transaction doctrine, all that is, what it basically means is that in the event that this whole strategy that the IRS looks at it and says, this is like, you're not holding these properties for investment. This is just meant to try to be a sham transaction to avoid the paying taxes. The IRS has the ability to look through the transaction and look at substance over form. So you want to make sure that in the event that you're doing any of these, that you're have a legitimate reason to do it, as well as an opportunity to hold another piece of real property for that investment period. Okay, this is the newest strategy. This is the newest and the last strategy that people are implementing around the country. And this is called for an installment note, or some qualified intermediaries around the country call this the PIN method, P-I-N, PIN method. So we're using a lot of acronyms tonight, everything from TIC to QI to EAT. Well, this is the last one, I promise you. It's called PIN, and it's dealing, and the PIN stands for promissory installment note. And the PIN method basically allows the qualified intermediary to act as essentially the issuer of promissory notes. And it allows them over time to pay out over those promissory notes. Remember the qualified intermediary, this safe harbor, the one that has taken all this cash in and they pay this over time. Usually it's over a structure of a year, sometimes a little bit more. So the downside, obviously, if you're an investor and you want your cash, you're like, hey, I want it now. I don't want to wait around for another year to allow you as the qualified intermediary to delve it out to me over a period of time. And so this avoids, obviously, the special allocation issues related to kind of like boot and things like that. But the reality is, again, the time as well as just the overall risks associated with the transaction, you may not want to proceed that. I would say in general, the vast majority of people that do these types of transactions do drops and swaps. They're not doing swap and drops, and they're not doing necessarily split offs, and they're not doing the promissory installment note method. But all of these are starting to get traction around the country. So, and you're going to see more and more of this. So regardless of the strategy, I want you to see this. These are the kind of the ingredients that you're seeing baked into each of these strategies. And one is just start thinking about it. So if you're a passive investor and you're thinking to yourself, hey, I don't really need the net worth or liquidity. Has the sponsor, the operator that I invested with, have they ever thought about this? Or if you're the sponsor and you're the operator and you're thinking to yourself, man, we bought this property 18 months ago and it's skyrocketed. We're going to, the investors are going to make like a 40 to 50% return on their investment. What are we going to do? Now we've got a tax problem. And maybe some of your investors aren't dragging losses, like the carried losses on the depreciation to be able to offset some of those taxable gains. So how are you going to help them potentially do that? Well, this is a mechanism for you as the operator or the sponsor to be able to start talking with your investors potentially about how to help them in connection with that. You need to be familiar with your operating agreement, or you need to be able to amend it if necessary, right? In order to do that. The documents necessary they're very repetitive, and they're a lot of the same things, regardless of what strategy you're looking at. So it's the deeds, right? It's the tenant in common related docs, and then there's assignments of the contracts that are actually put in place to actually sell that relinquished property, and you're gonna do replacement property. So those ingredients are there. And then if you want to offer this to your investors, I always say you need to make sure that you have a plan or a mechanism for them to express their clear intent, so that some of these investors know, because you don't want to just assume that all the investors are on board with this. Now, obviously, if they knew going into the investment that the operating agreement said, hey, if a simple majority or a super majority or unanimous consent, or the manager decides that we're going to go through a 1031, then that's fine. You signed up for that. But if that wasn't one of the risks associated with the transaction, or one of the issues presented to you as a passive investor, then or a sponsor or an operator, and you didn't discuss that, that isn't something that you should foist on anybody. You should have an opportunity and a mechanism, whether it's a ballot or a meeting or something, for them to be able to express their clear intent. You got to hire a qualified intermediary. Don't do it at the 11th hour. You're going to seek mercy at the 11th hour. You died at 10:30. You missed it. Don't wait. You don't need months to do this, but you definitely need at least some weeks to get somebody that you trust in place, that qualified intermediary that understands what your plan is in order to accomplish this. And then the last and most important thing, and I think this is important for every strategy, whether you're a newbie, investing, seasoned entrepreneur, investor, or syndicator, that is be kind, be patient, be flexible. These things will not turn out as you had hoped or wanted. Not all the investors will agree. That's why the vast majority of operators, still, it's like herding cats at the end, right? So we're not primarily doing this on every deal, and it might not be suitable on your deal, and that's okay. That's okay, but it's important for you to have at least the knowledge, right? So one of the reasons why you're here tonight, or why you attend this awesome meetup, why you're in fellowship or community with like-minded individuals, is so that you can learn from them about more information. Not that you have to act on everything that you learn about, but that you have that at your disposal, so that when the time comes, you'll be knowledgeable and you won't be ignorant about some of these things. So those are some of the very important things. And then I'm going to leave you with this here. All right, so this is one of my favorite taxes, and that quotes, and that is: the difference between death and taxes is death doesn't get worse every time Congress meets. Unfortunately, and I don't care. This is apolitical. This concept is totally apolitical. It doesn't matter whether you're Democrat or Republican. The fact is, every time Congress meets, the tax code continues to get larger and grow larger. So I would encourage you, anything that is good for investors, which is everyone should have the opportunity to invest, regardless of political affiliation. You should want to do this to help your family and your community and those people that you're in relationships with. So let me see if I've got some stuff in the chat, or maybe Ferris says, "Hey, enough."
You moderate, man. Clearly, Dugan is a wealth of knowledge. I mean, he's just on a roll. I'm surprised Dugan, I don't think, took a sip of water or had tea or anything. So we got to make sure we send you some water next time. So if anyone has questions, right, whether it's about 1031 exchange or, or syndication in general, please feel free, and I'll go ahead and moderate that and kind of ask the Dugan. And just a reminder for everyone, right, we will do breakout rooms at the very end where people can network. Dugan may stick around, and so you might get an opportunity to kind of have a little bit more of a smaller environment, but if you have questions, please go ahead and leave them. Or if you want to keep it a little bit more discreet, you can send it to me directly and I will read it. And so I think, Dugan, while you were kind of going through it, I think there was a lot of people asking for the recording. It's a ton of information. And so we will send out the recording. I think the team will send it out tomorrow, I believe, but you will get that in an email later. Let's see. So questions. No questions so far.
Fantastic. Love it.
All right. Well, I mean, I'll ask a question, right? How common is it, especially with just kind of the market that we've seen the past 12 months? How are you starting to see more operators explore doing a 1031, right? Versus, I think in the past, historically, it's, just didn't make as much sense. It's another thing to go figure out and do, right?
Yeah.
District equity, we actually haven't done a 1031 ourselves into another deal with our investors. But it's something that we seriously contemplating, just given the amount of equity that we're seeing on some of these deals, right?
Absolutely. So I'm seeing, I would say, I don't have the biggest sample size, but I think with the amount of transactions that I see on a yearly basis, I have a fairly decent idea of what's going on in the marketplace around the country, and it's becoming way more prevalent. And operators are starting to think of, they're starting to figure out, hey, I could take the same investors that I just hit a home run with, and maybe they don't need the liquidity, and we can now do an exchange, and now I can go find another opportunity and leverage up and do that. And now I can be more competitive on my bidding for deals. Yeah. So I'm able to say, hey, we can close in 20 days or 40 days, all cash or whatever. Now, the timing mechanism is the biggest challenge, but I'm seeing a lot of operators out there at least start thinking about, hey, is this something that would help me accelerate on the raise side? And then on the passive investor side, is this something that is worthwhile for passive investors? And it's all over the map, right? Because everybody's life experience is totally different, what they're going through or what they need or whatever. But it's definitely something that is becoming more and more niche, I would say, around the country.
Yeah. First questions investors ask after you tell them you're selling a deal and doing well, they're like, okay, what am I going to put my money into next? And so This makes that conversation a lot easier, right? There's not that need to find that next deal to start over with. So let's see, a few questions did come in. So first one is, do you know any person who can act as an EAT for reverse exchanges? Anyone that you recommend, Dugan?
Oh yeah, there's tons of great people out there that do EATs. So I've referred people over to Madison Exchange does EAT services. iPix is another one. These are fairly decent sized companies, so you can be confident they're not going to take your money and run away or do something shady. But not every qualified intermediary does EAT services. So you want to be able, if you're really thinking about doing the reverse exchange, you want to make sure that they actually have a track record. And then of those that do EATs, there's even a smaller amount around the country that would do an EAT in connection with like a syndication. So you're adding complexity to those sorts of things. These are very highly complex commercial real estate transactions, but there are people out there that will absolutely do that. And there are lenders out there, frankly, that will loan you the money to do the EAT side of it as well.
All right, good question. Next question, Dugan, can you give a brief case study of one of these exchanges, one where some investors wanted to exchange and others didn't? So maybe very added simplicity, maybe kind of walk through a hypothetical scenario.
Yeah, so I had a client recently who was in the process of selling a property, had a great purchase, wasn't thinking about selling the property, but because the property had appreciated so much in value over the last like 18 months, I think since they own it, they were going to realize millions of dollars in excess of what they were looking for, and they needed to deploy that capital again. This is somebody that constantly has deal flow, and so they're always doing another deal, and so they were able to match up that timing. So what they did basically was we hired a qualified intermediary, we put them in there, we generated a ballot so that all the investors were presented with a ballot, and those that did not want to do the exchange understood that their interests were being transferred from one entity to another entity. It was the same math, so they were going to receive the same payout regardless of what entity they actually sat in. The entity that we created went to closing, received their pro rata percentage, and I think it was like 32% was the entity that actually received cash and they paid their taxes, and the 67% went through the exchange process. And then they designated 2 or 3 opportunities, one of which happened to be the next deal that the sponsor kind of had lined up, and they provided the seed capital, which ended up being 75% of their raise. They were able to immediately have at their fingertips like that. That just happened in December of 2020. But I have lots of examples of that type of kind of experience because the pathway and the mechanics are roughly the same for people.
All right, thank you. Let's see, I did get a few more direct to me. So is there a way to 1031 single family proceeds to syndicated deals?
If your single family deals are commercial use. Now, if your primary residence, no, but if it's a single family deal, last year I had a deal where sponsors had a property. It was a property in Tennessee. They needed $5.2 million of equity in order to close on the loan. We had one 1031 party who had a 40 plus home single family residential portfolio, and he wanted to get into multifamily. So he sold his portfolio and banked all of the equity from the sale of that single family residential portfolio. And he was the sole investor in that acquisition, along with obviously the other entity had the sponsors in it. So that's an example of where somebody owned single family residential homes and they decided to go into a different asset class to get into multifamily, and they did so, and they were able to maximize and use all of the equity necessary to get in there.
Yeah, and I'll add too, I mean, you really need an operator that's comfortable doing with that amount, right? If the operator is raising $20 million and you're doing $100,000 1031, right? The economics don't make sense, right? In terms of getting all the complexity added to the deal. And so, because we get that question a lot, and maybe a rule of thumb, I like to tell people, if you want to do a 1031, you probably need to have $1 million or more to 1031, right? And I don't know, Dugan, if you'd agree with that rule of thumb, but that's typically what we've told investors from hey, will we accept 1031 money?
That's totally subjective, right?
Yeah,
So like
absolutely.
John's litmus test for what he might have might be different than what Ferris has, might be different than what other sponsors have. I have a client that won't do anything less than 8 million. I have another client that sets his limit at 3 million. I have another client that's at 1 million. I've got lots of clients that are like $500,000. I even have clients that do it for 150. So I would say the people that are on the 150, that's very few and far between. There's not, they're like what Ferris says, you got to be up a little bit more because of the added complexity, the increased cost of the transaction, which is not much, but the overall time pressure, that's the thing that the sponsors and the operators, they can't expand because it's reliant upon the seller to agree with them. And remember, the seller doesn't care. The seller just expects you to show up at closing with your checkbook. And if you don't have your money ready, they're not going to sit there and wait around for you to cobble together money from 1031 parties.
Absolutely. All right, here's another one that came in to me directly. As a passive investor in a syndication, does the passive investor establish the qualified intermediary, or is it up to the sponsors?
It's almost always the sponsors who will pick who the qualified intermediary is going to be if they decide to offer this in their deal as a whole. Just like, as a passive investor, you really literally can only vote on very few things, like your economic rights. Like, I'm not going to be artificially diluted. You didn't do a 70-30 and now you're telling me it's a 50-50, right? And there was nothing in the documents about that. That's the type of stuff that you're going to vote on, but generally very rare for you as a passive investor to have any voting rights or say if the sponsor chooses to do a 1031, they'll pick who the qualified intermediary is going to be.
All right, and then we'll do one last question. And you kind of answered this earlier, but if you can kind of maybe recap. We are selling a syndicated multifamily asset in DFW and identified other assets to purchase. Some of our LP investors have opted to the 1031 while others want to cash out. Can we bring in new investors to replace these investors and move forward with the exchange? Or does our company need to buy out investors?
No, you can bring in those new investors either before and you can essentially redeem the interests of the investors that want out. You can do that before closing, or you could do it after closing, and you could develop a mechanism. I would say the timing of those transactions are really going to drive what type of mechanism you build to put into place. But all of those are doable. And then obviously the timing factor. So remember, generally speaking, a secondary sale of a restricted securities in a private placement offering is not allowed within 1 year of the date of sale. So there's usually a 1 year lockout period dealing with restricted sales unless it's an affiliated transaction. But provided that you're outside of that 1 year, there's lots of ways that are kind of dependent upon what your loan documents say, right? But being able to allow passive investors out and new passive investors in, that's doable for sure.
Got it. Perfect. And now maybe I'll add one thing to that too, is if you're going to do 1031, do it sooner than later, because you do got to get things clear to the lender and lender legal, and there's a lot of structure mechanics to get sorted out. So
That's right.
All right. Well, we're going to call that a wrap. Dugan, do you mind putting in your contact information to chat for people? But thank you very much. Super informative, wealth of knowledge. And Dugan can talk, on and on and on about all the mechanics of it. So like I like to tell people, an informed investor is a good investor. So definitely, get out there, go get educated, and, get some exposure. And for those of you coming to the Multifamily Investor Network Conference this weekend, I'll be there. Anton will be there. John will be there, but so will Dugan. Dugan's going
I'll be there.
Yeah, he'll be there. So
Looking forward to it.
Pick his brain there this weekend here in Houston. And so thank you very much, Dugan. Really appreciate it. And with that said, Dugan, are you going to be able to stick around for the breakout, or you're going to have to hop off?
I've got 3 little boys and a wife.
Not a problem. I totally understand. So I just wanted to let people know. So Dugan won't be around. But that said, for those of you that have never attended, we typically do breakout rooms. We'll do one round and then we'll call it a wrap. All it is, we'll break up the group into a smaller group setting, right? Think 4 to 5, 6 people. And so it's a good way to get to network. Like John and I always like to say, your network is your net worth, right? It really is. You know, you never know who you're going to meet at these things. It's actually kind of crazy how some of these relationships start. And so it's really to put you all in a small group and just share something about you, right? Maybe share what you're up to this weekend, what you're planning if you're kind of stuck. So for those of you that don't know what to talk about, just share what are you up to this weekend? And, you know, maybe you'll meet someone interesting and maybe not. And so we'll do that for about 10 minutes and then we'll bring everybody back and we'll just leave the channel open for whoever wants to network in kind of one big environment. So with that said, I'm going to go ahead and kick off the breakout rooms and we'll see you guys here soon. Hmm. What? You don't feel so good? Heather, we're gonna go home, okay? See what happens when you cry too much. Yeah. Where did she go? Where did Tutta go? All right. With that said, hopefully people got some value from that. So hopefully people, someone met someone cool, someone new. And, again, you never know where these relationships would go. So like I said, we're big proponents of networking. We like to really push people to kind of get out of the comfort zone a little bit and go meet someone new. And so with that said, I'm going to go ahead and leave this open for whoever would like to network. And so I'm going to take off, but thank you all very much for hopping on. We do this every month. We will send an email out with the recording and kind of instructions on the next meetup. And so look forward to seeing you all either this weekend or in a month from now. Yeah, thank you all.
Thank you.
Thank you.
Thank you
Thanks.
for us.
And you guys can feel free, welcome to just sit here and talk. So definitely people hang out.
Charlie.
Yeah, I think he's
Let's go. Okay.
okay.
Well, let's go. Wait.
Who's going to be brave?
Yeah.
How are you all doing, guys?
Hey, there he is. He's back.
Yannick,
How's it going,
Angel,
Charlie?
look at this. How many people I know? How wonderful is this? Anton, we've met before. Sorry, Claudia. Okay, so what are we going to talk about, guys?
Well, Charlie, looks like you're going to take over as a host.